On to page 8 of the 1 to 4 family. This first section, 21 here, is going to be contact information. You do want to put your client's name, phone number, and email address in here, as well as your email. This is important to fill out, mainly for legal reasons in case there was something and they needed to give legal notice, but then also the title company, so that way they can get in contact with your client. Paragraph 22, this is where you're bringing in other parts of the agreement. So in this case, we know there would be financing. We say it is in an HOA. They have a home to sell. So I'm just kind of going through examples here. They want to do a appraisal protection. The seller wants a temporary lease. Those are really common, are more common ones. We don't see the other ones all that often. Those are the most common we'll see. We don't fill out like the attorney's information. I've actually never filled out because in 11 years I've never had clients hire separate counsel as part of it. And then this is where the clients would be signing. And then this is agent contact information. So in my template, I have this already filled out, so I don't have to go through and fill it out every time. With this, you would then fill out the agent's information from the listing on the multiple listing service. So you'd make sure to fill all of this out. When you click on it, it'll kind of prompt you to have to fill out everything. If you're doing a 2402, you'd put this here. I'm sure this little paragraph is going to probably disappear not too much longer in Texas, but for now it's there. And then this is just signature pages. So whenever the title company gets a copy of the contract and whenever they get the earnest and the option money, this is where they receipt that they have received said funds. And then for our brokerage, we have some additional disclosures that we provide specifically for the affiliated business disclosure and relationship with residential service contracts. So I have that in there as part of my default. And then this is for the 1 to 3, the third party financing addendum. So this is specifically for if they are getting a loan and what kind of loan. So this is information you will obtain from their pre-approval. And this is also where you would fill out as far as how much they're borrowing, and what interest rate. This does give them some protection if that interest rate ends up being a lot higher than is quoted. And this is where you would determine what type of financing, which will once again be specified on the disclosure on the pre-approval. We don't really see the Texas veteran loan. I've never done one of those. So it's normally going to be conventional, FHA, VA. Very rarely do I do USDA. I've never done a reverse mortgage, or other financing really isn't applicable either. With FHA, there are two main kinds, but this would be a 203B is normally the type of FHA financing we'll see. Once again, it'll be on the disclosure or on the pre-approval. But in this case, like I would list, whatever they're borrowing on here. And then on page 2 talks about the approval of financing. So this is basically putting you on the clock as far as getting approval. And it basically gives the buyer the right to terminate and get their earnest money back if they get denied for the loan. So normally we'll put 18 days or 21 days, something like that. It says if buyer cannot obtain buyer approval, buyer may terminate the contract within X number of days after the effective date of the contract by giving notice and providing a copy of a statement from the lender setting forth basically saying that they're denied. Sometimes buyers feel really, really confident of their approval, and to make the offer look a lot more strong, we'll sometimes select the second option. But even when my clients do feel pretty good about their financing, we will normally write that in still, because that would basically, if they lost their job suddenly or something, that would protect them. The second part you're filling out here is specifically for FHA and VA. If it is not FHA or VA, you leave this blank, but this is a federal mandate basically protecting the buyer if it doesn't appraise. So if we have a $400,000 sales price and a VA or an FHA financing, you'd put $400,000 there, not the loaned amount, but the sales price there. And it says that it needs to appraise for at least that much. Otherwise, the buyer has the right to renegotiate and or terminate and get their earnest money back. On conventional, that protection is not built into the contract. We have an extra form if you want to give them that protection. The next form I'm going to go over is the mandatory homeowners association form. So this is where address, city there, and then name of HOA that will be listed on the listing as well as that phone number. So you just add those there. And then these are giving a certain window of time for the seller to provide documentation. So this would be, normally we put something that's long enough that it gives you some time, but you will notice it says within 14 days after the effective date, the seller shall obtain, pay for, and deliver the subdivision information to the buyer. If the buyer delivers the subdivision information, the buyer may terminate the contract within 3 days after the receiving the subdivision information or prior to closing, whichever occurs first, and the earnest money will be refunded to the buyer. If the buyer does not receive the subdivision information, the buyer, at the buyer's sole remedy, may terminate the contract at any time prior to closing, and the earnest money will be refunded to the buyer. So what this means is if you put 14 days and they provide it on day 15, your buyer can terminate literally at any time, get their earnest money back. If they provide it within 6 days, then they still have 3 days after receiving it. The buyer may terminate the contract within 3 days after the buyer receives the subdivision information. So your client has the right to have 3 days from the date of receipt to review it, which is important. That is one way that technically, if you had an inspection window but ended up running out of time, but they hadn't provided the HOA documents, that would be a protection or a way out, technically. Or it could be just a way that your client has an opportunity if they're on the edge about, oh, I want this house, but I want to make sure that I can do X, Y, Z. I want a privacy fence, or I want to put an 8-foot fence, and I want a chicken coop. Well, now they can get the copy of the HOA restrictions, the subdivision information, and then determine if they want to move forward or not. Other forms here, this would be instead of the seller paying it, the buyer paying it. We don't really see that happen. We see seller pay. And then we also I never really see anybody fill out that the seller has received the information before signing. A lot of times those HOA documents are time specific and buyer specific even. And so like I have had cases where we've gotten the HOA documents and then they've expired and we've had to have them reordered all over again. Part of this cost can vary based on who the HOA is and what forms they have or what fees they have associated. I have seen some be $3,000. We have some gated communities in our market that can be quite expensive, but we have some other ones where they charge $50. On average, though, I would estimate a $400 cost for these documents, and then I would estimate another $400 or $500 for the fees as far as leaving the HOA. They kind of kick you on your way out with some extra fees that they can force you to do, because you can't close on the house or sell the house without it. So they kind of kick you on the way out. And then there are sometimes some kick you on the way in fees as well. The only time I ever see like buyer does not require delivery of subdivision information is if it's an all cash transaction, because the lender needs to see those too. So we don't really see them omitted. And then the information, like it says here, is obtained by the title company. So normally a house goes under contract, it's in an HOA, the title company will ask the seller to pay via a link to get the documents. The documents are delivered to the title company, and then the title company is the one that sends them out to all parties. But the seller does have to pay for those documents. And a lot of times I'll have my sellers hold off until like the inspections happened, and then we'll order them as soon as we can after that, just depending on what that number of days are here. Because if it's like 4 days there, that's not good, because then it's going to cause us to not meet this requirement to get them in within the 4 days. So that's why you'll normally see at least 10 days listed there. This amount right here is that the buyer shall pay some of the association fees, deposits, reserves, and other charges for transferring not to exceed the following. So essentially there will be fees on the closing disclosure, those kick you in, kick you out fees, and so the seller or the buyer is saying that they will pay up to this amount to help towards that cost. So it's just basically a fee, or the seller is getting a credit from the buyer for that on the closing disclosure. And then lastly right here, It's saying if for some reason the documents were not provided, who would be responsible for paying for those documents. So that's the HOA form. So only needed if it is in a homeowners association. Next one I've got in my little example here is the non-realty addendum. So this is something you would write in on paragraph 22 if you were adding this addendum into the contract. Once again, it'll autofill the address, and then you'd be saying what those non-realty items are. A great example would be a refrigerator. Ideally, you will list the brand and color and location, as much information as you can. Same with if it's a washer dryer, if they're leaving outdoor furniture, anything that would otherwise be considered a non-realty item. If they just kind of willy-nilly say, or the agent says at like the open house, oh yeah, we're going to leave that. That's great. I want to make sure it's in writing, just so that way you don't have a he said, she said, or your client moves in and is disappointed to see that something from a verbal agreement was not left. So I want it always in writing. Even if it's a vacant property that's empty and has a fridge sitting in it, I want to list it on here because I want the sellers to understand our expectations it's going to stay. I have seen them sell them to a neighbor or give them to a friend, not realizing that the buyer really wanted them to stay with the property. Next one is the seller's temporary lease agreement. So this is where the buyer would become the landlord. The tenant would be the seller for the address. This is where you'd specify how long or what date. I will often put that it doesn't end at midnight, but rather puts that it ends at like 5 p.m., something like that. So I'll write in a date at 5 p.m. Customarily, especially if it's under 14 days, we won't necessarily require a rent, so I would put 0 there. However, I feel strongly that a deposit needs to be included because otherwise, if the seller creates damage on their way out or they stay after the allotted number of days or date, then it's really hard to recoup that expense unless it's already been deposited. A lot of times the title company, because they get a copy of this, will actually have that on the closing disclosure as a fee. So the seller will pay that fee part of the closing disclosure. And then just like with a traditional rental, the fee is reimbursable to the seller or the tenant within 30 days. So say it's a 2-week lease back, the house closes, the tenant stays for 2 weeks, then they move out and the new owner moves in. They just need to give an itemized list identifying what they're withholding some of that money from. Otherwise, they're legally required to refund that money to the previous owner. Normally here, the buyer is not responsible or the landlord is not responsible for utilities. The buyer or the seller, the one that was the owner, is going to keep their utilities going, so they are responsible. So I put none there. I normally write into here already living in property. You know, the seller, you don't necessarily know what all the pets are that the seller has, but presumably they'll want to keep the pets that they already had for a couple extra days while they're there. And then I do require that the seller gets renter's insurance during that time because the new landlord has a homeowner's policy that will protect the house itself as far as a hailstorm or a fire, but the tenant's personal property would not be protected. And then I also want to make sure the expectation is that the seller is going to remove trash and personal items. This homeowner is going to be responsible for maintenance items. So based on this right here, it says the tenant is responsible for maintenance of the yard and then also shall make prompt repairs at tenant's expense, directly or indirectly caused by the tenant. Or anyone else other than the landlord. Now, with that being said, I have had a case where the new owner had a home warranty and the AC went out, and we were able to coordinate with the new owner to call the home warranty company to have them come out rather than the tenant expense. Not normally an everyday issue though, especially when it's a short period of time. Identification about insurance coverage there. And then a big thing is this holdover fee. So like I was alluding to earlier with having that deposit, if the tenant stayed past their welcome, then you would write in this here, which would be your daily rent past that period. So normally I'll put $250. That way it hurts a little as far as if they're staying longer. And so if you have a deposit, you could just deduct it from that. If they didn't have a deposit, now you have to, get lawyers involved and sue them in order to get that money recouped, which is why we have the holdover fee in there. I've only really ever had it come into play once where a tenant stayed longer than they were supposed to. There is another form. If you're using this, you're also required to give this landlord floodplain and flood notice form as well, which is what we're going to go over right now. And then it's contact information for landlord and tenant up there. So this is that flood notice. So once again, it would be address. And then this would just be saying that you're not in, nobody's aware of it being in a floodplain. If it is, then obviously change the answers. But very rarely do we run into it actually being in a floodplain.